Your chief judge just informed you that in 2 weeks, you're starting your first rotation in a criminal division. You checked your new division's docket, and there are 5 criminal jury trials set during the first week of your assignment. The last time you dealt with criminal law was in law school 20 years ago. As panic sets in, you feel your heart pounding, and you experience cold sweats. There's help. The Bench Basics Criminal Law chapters to the rescue. These chapters are here to help you and should be music to your ears.
Don't worry about a thing, 'cause every little thing gonna be alright.
Hi, my name is Carlos Zamor, and I am a district court judge in the 18th Judicial District. In this chapter, I will discuss in some detail motions for judgment of acquittal and the Curtis advisement. I will then say just a word about jury instructions, and I will conclude with a few remarks about the right to bail after conviction. Let's begin with motions for judgment of acquittal. In criminal jury trials, the defense may make a motion for a judgment of acquittal either at the close of the prosecution's case or at the close of all the evidence. Motions for judgment of acquittal are governed by Rule 29 of the Colorado Rules of Criminal Procedure. I will not read the rule here, but you should review it. How should you resolve a motion for a judgment of acquittal? The test applicable to a motion for a judgment of acquittal was adopted by the Colorado Supreme Court in the seminal case of People v. Bennett and is commonly known as the substantial evidence test. In Bennett, the court articulated the substantial evidence test as follows: whether the relevant evidence, both direct and circumstantial, when viewed as a whole and in the light most favorable to the prosecution, is substantial and sufficient to support a conclusion by a reasonable mind that the defendant is guilty of the charge beyond a reasonable doubt. The court in Bennett explained that when a trial judge is confronted with a motion for a judgment of acquittal at either the close of the prosecution's case or the close of all the evidence, he must determine whether the evidence before the jury is sufficient in both quantity and quality to submit the issue of the defendant's guilt or innocence to the jury. In order to withstand a motion for a judgment of acquittal, the prosecution has the burden of establishing a prima facie case of guilt and must introduce sufficient evidence to establish guilt beyond a reasonable doubt. No more, no less. In determining whether the prosecution has satisfied this burden of proof, the trial judge should not attempt to serve as a 13th juror or invade the province of the jury. Rather, the trial judge's responsibility is to prevent a case from being submitted to the jury when the prosecution has failed to meet its burden of proof. Why is a judge's authority to enter a judgment of acquittal limited? The limitation is premised on the basic principle that the jury, not the judge, should decide the difficult questions of 1. Witness credibility, 2. The reasonable inferences that may be justifiably drawn from the evidence, and 3. The weight to be given the evidence, including conflicting items of evidence. In terms of witness credibility, it is important to note that only when a witness's testimony is incredible as a matter of law may the court properly reject it. Testimony that is incredible as a matter of law is testimony as to facts which the witness physically could not possibly have observed, or events that could not possibly have happened under the laws of nature. Consequently, testimony that is merely biased, inconsistent, or conflicting is not incredible as a matter of law and may not be rejected by the court. So, to summarize, when ruling on a motion for a judgment of acquittal, the trial court is bound by 5 well-established principles of law. 1. The court must give the prosecution the benefit of every reasonable inference. 2. The determination of the credibility of witnesses is solely within the province of the jury. 3. The trial court may not serve as a 13th juror by determining what specific weight should be accorded to various pieces of evidence or by resolving conflicts in the evidence. 4. A modicum of relevant evidence will not rationally support a conviction beyond a reasonable doubt. And 5. Verdicts in criminal cases may not be based on guessing, speculation, or conjecture. This summary, by the way, comes from People v. Sprouse, a Colorado Supreme Court case. Now, a practical pointer. When I get a motion for a judgment of acquittal, I ask defense counsel to identify the element that he or she believes has not been proven. I want to know why counsel believes the prosecution has failed to meet its burden of proof. Once an element has been identified, I think about all the relevant evidence that has been introduced, regardless of whether by the prosecution or the defense, and I ask myself, if a reasonable juror resolves any conflicts in the evidence in the prosecution's favor, draws all the reasonable inferences that are favorable to the prosecution, considers the evidence in the light most favorable to the prosecution, and gives the evidence favorable to the prosecution as much weight as possible, would that reasonable juror conclude that the evidence is sufficient to prove the element in question beyond a reasonable doubt? I grant the motion only if I conclude that a reasonable juror would necessarily find that the evidence is not sufficient to prove the element under challenge beyond a reasonable doubt. Let me move on now to the Curtis advisement. Of course, Curtis does not refer to Cowboy Curtis, the goofy character played by Lawrence Fishburne on Pee-wee's Playhouse. Curtis refers to the name of a case decided by the Colorado Supreme Court in 1984. In People v. Curtis, the court held that a defendant's constitutional right to testify in his own defense is so inherently and intensely personal and so basic and fundamental that procedural safeguards, like the ones concerning waiver of the constitutional right to counsel, are required before the court may accept waiver of the right. There are certain constitutional rights that are sufficiently personal and fundamental to require the procedural safeguards concerning voluntary, knowing, and intelligent waiver established by the United States Supreme Court for the right to counsel. These include the privilege against self-incrimination, the right to trial by jury, the right to confront one's accusers, and the right to be present at each step of a felony proceeding. In Curtis, the court added the defendant's right to testify at trial to this select group of constitutional rights. These rights are different than other rights, as to which counsel stands as captain of the ship and has authority to make binding decisions on the defendant's behalf. Curtis requires that the trial court advise the defendant on the record, but outside the presence of the jury, about both the nature of his right to testify in his own defense and the consequences of exercising that right. The court must also satisfy itself that the defendant is cognizant that he may take the witness stand notwithstanding the contrary advice of counsel. The court in Curtis identified 5 elements of an appropriate advisement. The trial court must advise the defendant that 1, he has a right to testify. 2, if he wants to testify, no one can prevent him from doing so. 3, if he testifies, the prosecution will be allowed to cross-examine him. 4, if he has been convicted of a felony, the prosecution will be entitled to ask him about it and thereby disclose it to the jury. And 5, if the felony conviction is disclosed to the jury, then the jury can be instructed to consider it only as it bears upon his credibility. Curtis also instructs that, pursuant to the privilege against self-incrimination, the court should advise the defendant that 1, he has a right not to testify, and 2, if he does not testify, then the jury can be instructed about that right. Now let me share some practical pointers by discussing my standard courteous advisement. At the beginning of my courteous advisement, I ask the defendant to confirm that he can hear me and understand me clearly. I question the defendant about his age, his level of education, whether he is under the influence of alcohol, drugs, or any medications, whether he is currently suffering or has suffered in the past from any mental health disorder or psychological problem that affects his ability to think clearly and understand the proceedings clearly, and whether he is fully alert and able to concentrate and make decisions on important matters. If the defendant's response to any of these questions is concerning, for example, if he indicates that he's under the influence of medications, I explore that further to ensure that whatever medications he is taking do not interfere in any way with his ability to think clearly, to understand the advisement clearly, and to make important decisions. Don't be scared to follow up on those issues. Remember that under Curtis, the serious and weighty responsibility of ascertaining whether a waiver of the right to testify is knowing, intelligent, and voluntary rests with the trial judge. Next, in my courteous advisement, I cover the 7 elements of the advisement our Supreme Court has articulated, including the 2 related to the privilege against self-incrimination. As I advise the defendant about each element, I ask, "Do you understand?" and wait for his response. When I get to the element regarding the prosecution being entitled to cross-examine him and to elicit any prior felony convictions, I ask the prosecution to state on the record whether it is aware of any felony convictions and, if so, to list them. If I have allowed the jury to submit written questions for the court to ask of witnesses, I inform the defendant that the same procedure will apply to any questions the jury may wish to have the court ask of him on the witness stand. I add that the same rules that apply to attorney questions also apply to juror questions. In the last part of my courteous advisement, I ask the defendant if he understands both his right to testify and his right not to testify in the trial. I then ask the defendant if he has discussed with his attorney whether he will testify in the trial. I follow up by asking the defendant if he needs more time to discuss the matter with his attorney. After the defendant represents that he does not need additional time, I ask if he has made a decision as to whether he will testify in the trial. When the defendant informs me that he has made a decision, I ask him to state that decision. I then inquire whether this is a voluntary decision. I also request that the defendant confirm that this decision was not made as a result of coercion, pressure, undue influence, threats, or promises. When I have satisfied myself that the defendant's decision has been made knowingly, intelligently, and voluntarily, I make a finding to that effect. This finding is very important and should be made after the advisement in every case. Now, let me give you a caveat. The court in Curtis observed that the advisement it adopted was not meant for the narrow class of cases where a prior felony conviction is an element of a crime charged. It is error for a trial court to advise the defendant that a prior conviction will only be used to impeach his credibility where the prior conviction is actually an element of the crime charged. An example is possession of a weapon by a previous offender. In such cases, the trial court should provide a modified courteous advisement. This concludes the discussion on the courteous advisement. And now, just a brief comment about jury instructions. Jury instructions are obviously very important in criminal jury trials. I do not have sufficient time here to discuss all of the jury instructions. However, I want to point out that we have the benefit of the Colorado Model Criminal Jury Instructions. Please consult them in every trial before instructing the jury. They are available online and they are being regularly updated. I also want to strongly encourage you to have your jury instructions conferences in their entirety on the record. Let me conclude now with just a few remarks about the right to bail after conviction. You should be aware of Section 16-4-201 and Section 16-4-201.5. I am not going to go through every provision in these statutes here, but let me highlight a few points. First, a surety bond may not continue in effect after a guilty verdict or a guilty plea without the written consent of the surety. Second, following a conviction for a felony, the court must require, as a condition of the bail bond, a written waiver of extradition. Third, no bail is allowed if the defendant is convicted of certain offenses listed in Section 16-4-201.5, subsections 1A through G. Finally, even assuming the conviction in question is not on that list, the court may not set bail unless it finds that the defendant is unlikely to flee and does not pose a danger to the safety of any person or the community, and that his appeal is not frivolous or is not pursued for the purpose of delay. I hope that this has been a little helpful. At a minimum, I hope that when one of the subject matters I have covered here is raised in your courtroom, you will not get frustrated or cry or yell at the lawyers or completely lose your marbles. Thank you very much for your time.